Your Honor, this matter is before the court in the interest of Andre Montgomery before the court for an arraignment on petition number 269-781, failure to report child sexual abuse. Andre is represented by attorney Curtis Bowe. Also before the court is Alec Navely before the court for an arraignment on petition number 269-778, failure to report child sexual abuse. He is represented by attorney Lee Davis. Also with Lee Davis's office is attorney James Barnell. Also before the court is Carl Williams before the court for an arraignment on petition number 269-783, failure to report child sexual abuse. Mr. Williams is represented by attorney Johnny Houston. Also present in the courtroom from the DA's office is DA Neil Pinkston, Assistant DA H.C. Bright, and also present is investigator from the DA's office, Lisa Mathis, and from Hamilton County Sheriff's Department, investigator Nikki Roundtree.
All right, we're here this morning. It's no secret to address the allegations regarding violations of Part 400, 403, etc., 37, 1, 403, and those statutes, as well as 605. The court just received this morning 2 additional filings and motions that I had to read before coming in. Is the state ready to proceed?
Yes, Your Honor.
Mr. Houston, Mr. Bowe, and Ms. Barnell, Mr. Davis, are you all ready to proceed this morning?
Yes, sir.
Yes, sir.
All right. Mr. Pinkston, what's the status of the case?
It's set today, Your Honor, for arraignment for the 3 individuals. As I understand, according to the statute, they either enter a plea or not, and if they plead not guilty, the court pushes it to the grand jury. I understand they filed motions that we can address from the court if the court wants to do it today or some other day.
Are you all ready to proceed on your motions?
We're ready.
Yes, sir. And I think that would be the first order of business. Who wants to go first? Mr. Houston.
I have another copy that is in my briefcase. May I get him the other copy, Judge? All right, may it please the court, Johnny Houston here on behalf of defendant Carl Williams. Your Honor, we think the case is just a tad more complicated than pleading guilty or not guilty. Otherwise, this court would simply be just a rubber stamp for the DA's office. We have filed a motion to dismiss that we'd like the court to consider prior to the entering of any pleas. Our motion to dismiss, which we gave to the court this morning, I'm not sure if the court needs additional time to hear it or to read it because it is a little bit late, but assuming the court wants to go forward on it.
I agree with your motion.
Okay.
As well as Mr. Post this morning, the young one yesterday.
All right. Basically, Your Honor, we have filed a motion to dismiss for 3 separate reasons, and we think the case should be dismissed for 3 separate reasons. First of all, we believe that this court has no jurisdiction to hear this case. I have attached, of course, the summons as well as the affidavits of Mr. Roundtree and Ms. Mathis. As the court can see from reading the summons, which of course the court, not the summons, but the complaint filed by the DA, there is no reference in the complaint to the location where this occurred. You don't find that out until you read the affidavits of Ms. Mathis and Mr. Roundtree. If you go down to paragraph 4 of the affidavit of Mr. Roundtree, and the affidavits I will state are identical. Paragraph 4 says, the investigation revealed the Ooltewah High School basketball team traveled to Gatlinburg in December and stayed at a cabin from approximately December 19th through the 23rd, 2015. The purpose of the trip was to perform in a basketball tournament. The very next paragraph, which is the essential paragraph, during the team's stay in Gatlinburg, 4 freshman basketball players were subjected to assaultive behavior, including but not limited to being struck with pool cues, and also these 4 freshman basketball players were subjected to apparent sexual assault. 1 player required emergency surgery due to the injuries he received while staying at the cabin. The face of these affidavits indicate that any assault, be it sexual or non-sexual, occurred in Sevier County, not in Hamilton County. It's our contention that it would only be appropriate for the Sevier County courts to consider this matter. Now, if we look at the statutes, of course, the statutes require immediate reporting. Immediate would have to be while the parties are in Sevier County, not Hamilton County, Sevier County. Based on that alone, we don't really think the court should go further because this court simply has no jurisdiction. As everybody knows, I'm the judge in Red Bank. I can only handle matters that occur in the city of Red Bank. I cannot handle matters that occur in the city of Chattanooga. It's no different here. Rule 18 of the Criminal Rules of Criminal Procedure states, except as otherwise provided by statute or by these rules, offenses shall be prosecuted in the county where the offense was committed. If the reporting requirement is immediate, again, the only county where this could be prosecuted is Sevier County. So that's our argument with respect to the appropriate venue. Next, we think the charging instrument is insufficient as a matter of law on its face. There are 3 things that, let me go back here. The 6th and 14th Amendments guarantee that Mr. Williams must be put on notice as to the nature and cause of the accusation. We contend that the complaint that's been issued, as well as the accompanying affidavits, are insufficient. Generally, there are 3 things that are required in charging instruments. There must be sufficient information, first, to enable the accused to know the accusation to which answer is required. Second, and one that is often forgotten, is to furnish the court adequate basis for the entry of a proper judgment. And 3, to protect the accused from double jeopardy. As we all know from handling criminal cases, the essential elements of the offenses must be contained in the charging instrument. While not necessary to go through all the essential elements, I think the court can take notice they're not there. They're just not there. Second, and again, as we all know from practicing in criminal court and even in the lower courts, prior to the entering of a plea, the state always gives the factual basis for the plea. $37,160.605 requires immediate reporting. It also defines child sexual abuse as 13 years of age or under. It's defined actually in 602, I believe. Had that been alleged in the complaint, I don't think this court would have issued it. Now, I see the court maybe not agreeing with me on that.
Well, there are several definitions in that section, and you're exactly right as to one, because it's further defined as other things.
Right, and here, as I understand it, the accusation is that they failed to report sexual abuse.
Which is defined in several different ways.
Well, we contend that in 602, it's defined as 13 years of age or under. Of course, in the charging instrument, it's not defined at all. So that essential element is lacking. Finally, Rule 4 of the Tennessee Rules of Procedure provide that if an affidavit of complaint establishes that there is probable cause to believe that an offense has been committed and that the defendant has committed it, the magistrate or clerk shall issue an arrest warrant. The court's order states that there were reasonable grounds. Probable cause is the standard required. We don't think that standard has been met. Again, I refer the court to 37-1-602, which defines child sexual abuse. Refer the court to the failure to allege the essential elements of the offense, and will state that there just simply is no probable cause. As a judge, I've often been called upon to, well, every week called upon to issue warrants. We all know officers are eager to provide the court with information beyond what's in the affidavit. If we only look at the four corners of these identical affidavits, there's simply not probable cause to issue the charge or these charges. And for those reasons, we would ask that the case against Mr. Williams be dismissed.
Thank you. Mr. Poe?
Your Honor, Curtis Bill on behalf of Andre Montgomery. And for Mr. Montgomery's part, with respect to the request to the court to dismiss this complaint lodged by the district attorney, we wrestled with a number of different things. First, the constitutional arguments that Mr. Houston gave to the court.
And let me just say, I don't mean to cut you off, but let me say, we have wrestled with some things too. 403 and 605 don't always agree. There's some argument that can be made 605 is included in 403. There's arguments that can be made that it's not included. And what's required in the procedure involved seems to differ on 403 and 605. So, you know, I'm just an acknowledgement that I'm with you. Okay?
Thank you, Your Honor.
I'm with you on the complication
Yes,
of what is otherwise a Class A misdemeanor. And so it's complicated, and the statutes are poorly written, and the legislators need to address it.
And that goes to Mr. Montgomery's issue, Your Honor, as I'll lay out, that not only are the constitutional protections afforded with respect to, as a defendant being charged and having notice provided by the district attorney of the exact factual circumstances that cause and give rise to a duty to do, as the state says, mandatorily report. But also, there is the issue of statutory interpretation, which is important in this instance. It's important for a number of reasons. First, TCA 37-1-102 defines specifically child abuse, and it defines it for every statute under Part 37. Further, TCA 37-1-602A-3D specifically defines child sexual abuse. Not only does it define it as 13 years of age or under, but it also says for 13 to 17. And both statutes, 102 and 602, define abuse, child abuse and child sexual abuse, as only perpetrated by a parent, custodian, relative, caregiver, individual residing in the child's home, or other person responsible for the care and custody of the child. None of that's pled in the state's complaint. None of that's contained in the factual allegations of the affidavit. And most importantly, none of that is true under the facts of this cause. The alleged perpetrators are 15 16, and 17.
You're saying your client was not in the care, or the children were not in the care of your client?
I am saying that the children were in the care of my client, but my client did not perpetrate any assault upon the alleged victim. And that's how the statute is written.
I believe that's that section, because I want to hear from you, it also says inaction, doesn't it? Inaction or inaction.
And I will address that as well, Your Honor, for a couple of different reasons. But the alleged perpetrators were 15, 16, and 17, thus disqualifying them under the definition contained in the statute, which cannot be ignored. Additionally, the victim is 15, over the age of 13, qualifying him under the 13 to 17-year-old portion, which also says has to be a parent, custodian, guardian, relative caregiver, someone living in the home, or someone with custody of the child. Also inapplicable. Under 403, there is no defining definition of what constitutes child abuse. There is only one list of what rises to a duty of reporting. That list is abuse, which we've already discussed, and it's inapplicable under the statute. Neglect, which the state hasn't charged. And there's that term brutality, which is undefined by statute, which the state also has not charged. It is sexual abuse and child abuse that they have charged in the complaint. We cannot create a complaint that the state did not file, and we cannot address issues of the complaint that the state did not file.
I should have asked Mr. Houston the same question. What do you say about 403 not even requiring a complaint at all?
Unfortunately, Your Honor, it's not 403 that requires the complaint. It's 605. And that's what brings us here, is that someone has to initiate something.
Well, 403 brings us here too.
Yes, Your Honor. Procedurally, 605 brings us here, and someone has to initiate a filing with the appropriate court. We too contend that Hamilton County is not the proper place for any action related to anything that happened in Sevier County. That's Sevier County's jurisdiction, not here. Returning to Mr. Montgomery's argument, Your Honor, the crux of this matter is simply this. There is no factual assertion contained in the complaint or anywhere in the affidavits to provide Mr. Montgomery with notice that anything that triggers a duty to report in this case was met. There's no assertion that he had knowledge immediately. There's no assertion that he facilitated the conduct. There's no assertion that he failed to provide aid. And in fact, the truth is, he immediately responded and took the child to the hospital twice. Was with the child the entire time, and only until the hospital visit occurred was he fully informed of what happened. And at that point, a report was made. He participated in that report with law enforcement. He did everything he was supposed to do, because this is not child abuse or sexual abuse by 15, 16, and 17-year-olds. This is a sexual assault. It is a criminal assault, and only a criminal charge. Accordingly, 403 and 605 are inopposite and cannot rest to bring this man to be required to report. He reported to law enforcement. Law enforcement charged. They charged in Sevier County. They investigated. They cleared these three individuals from any wrongdoing whatsoever. And, Your Honor, I would add that includes whether or not they had to report. And they cleared them because, recognizing that it's not child sexual abuse or child abuse as defined under Tennessee law, it is simply a crime and an assault, a horrific one, but a crime and an assault, which does not cause mandatory reporting. If the legislatures thought that they needed to include child-on-child violence, child-on-child crime, however horrific, they would have defined that in that section, and they did not. Because they recognize that were they to do so, Your Honor, DCS, the District Attorney's Office, would be overwhelmed, because every time a child got into a fist fight in a cafeteria or a pushing match in school or on a football field or a baseball field, they fought. Your Honor would get a call, DCS would get a call, the district attorney's office and law enforcement would get a call and be overwhelmed. The reason the statute's written the way it's written is to protect children, and that's clear because it says so in the very beginning portion of 37-1-401. It's to protect children from those adult individuals who could do them harm, and that's not what the complaint charges here. It simply says that there was a mandatory duty to report, and unfortunately in this instance, as the statute is written, and as Your Honor commented, written poorly, there was no duty to report because the definitions of child sex abuse and child abuse are not met. What we also have is a final argument, which is the state contends that 403 is applicable because of some knowledge requirement. And as we've already discussed, Your Honor, there's nothing in the complaint that puts Mr. Montgomery on notice of a timeline of said knowledge. Even the affidavits fail to do so. What the affidavits do is recite and recant what social media, inaccurate journalism, and other reporting has done to create unfortunate community response to a problem that occurred in Sevier County. Sevier County has dealt with that problem. They've charged the individuals responsible for the assaults. Those individuals, I understand it, 5 days from now will be heard before Judge Stokes, and they will have to deal with their issues. None of that impacts these three gentlemen, and particularly Mr. Montgomery, because the state's failure to lodge in the complaint a timeline that says, this is what you did, or conversely, this is what you didn't do. Not just fail to report, but how. At 9:15, you knew X. At 10:23, you knew Y. The state didn't do that. And that's a constitutional deficiency that requires dismissal. Your Honor, I can't be any clearer on behalf of Mr. Montgomery with respect to anything but this. As a coach, incorporating these 14 young men into his life, participating with them just as he should, teaching them just as he should, the state has not brought to you anything that meets with what Tennessee law as currently written says, or by definition under the statute requires. And as a result, the complaint against Mr. Montgomery should be dismissed.
Thank you, Mr. Potter.
Good morning, Your Honor. Good morning.
Your Honor, I represent Jesse Nadley, and I am not going to repeat the grounds that are alleged by co-counsel. You have our motion, and we've raised the different grounds, and I think the court has those well aware. I just would like to point out a couple things that are different about Mr. Nadley's situation for the court's attention. On the complaint that was filed with the court in the supporting affidavits on paragraph 5, and this is in Detective Mickey Roundtree's paragraph, he states, during the team's stay in Gatlinburg, 4 freshman basketball players were subjected to assaults of behavior, including but not limited to being struck with pool cues, and also these 4 freshmen basketball players were subjected to apparent sexual assault. 1 player required emergency surgery due to the injuries he received while staying at the cabin. We believe that ought to be true. We think this is a very serious accusation. We think that the prosecution of these individuals is of the greatest importance to the state. What I want the court to consider is that one of those 4 freshman basketball players, one of those victims, is being further harmed by these proceedings. That is Jesse Nadley's son. My client was up there as a father that day, Your Honor. Nowhere in the paperwork does it reflect to you. And the reason my motion is a little bit different, I've asked for you to rescind this order because you were presented with information and asked to issue a summons to haul Mr. Nadley into court to answer the requirement why he didn't report anything. I don't believe it's ever been disclosed to you, and I don't believe you've ever been informed of the fact that Mr. Nadley, his wife, and his daughter were up in Gatlinburg to see their son's team play basketball. Jesse Nadley's son is one of the victims in this case, and that is a fact. Mr. Navely was not up there as an athletic director. He was not staying there in the cabin. He was miles away. I think by Google it shows he was 10 or 12 miles away from where he was staying, where the basketball team stayed. As soon as he heard of these allegations, he informed his principal, and the principal informed the superintendent, and the chain of information flowed the way it was supposed to back through the school system. But the part I want to focus on is your order. It says, this matter came before the court upon complaint filed ex parte. Ex parte meaning we were never asked, Mr. Navely was never asked to be part of it. Having found reasonable grounds to believe the defendants violated reporting requirements, you issued this summons. Well, when we go back to the complaint, we look at, well, what is the reasonable grounds? And I imagine the reasonable grounds are similar to probable cause. In this complaint, it says that Allard Navely, Jesse Navely, acting in his capacity as assistant principal and athletic director. Nowhere in here were you ever presented with the fact that Mr. Navely was, in fact, in Gatlinburg as a father with his wife and with his daughter, that his involvement was there as a parent. This man has been savaged in the media. Just last night, somebody sent me a Facebook account where they are demanding that he be imprisoned and his attorney be killed. He has been savaged because people are saying that he somehow is involved with this. That's where it becomes important that you do your part in looking at the four corners of this complaint and the supporting affidavits. If you look at this complaint, the part that starts with the caption and ends with the signature of the district attorney, there is nothing in it that gives this court jurisdiction over Mr. Navely or gives this court probable cause to believe that Mr. Navely has been involved with anything. There's nothing there. I mean, if you read it, you literally don't have a date.
Mr. Davis, how do you get around the reading of the 403 statutes that don't even require a complaint?
No, what I'm
It
saying...
says when the juvenile judge becomes aware of.
Okay. You've got to be aware of something. If you were told here and you said that Mr. Navely's son is the victim of a sexual assault, and that as a father of a victim of a sexual assault, he's been told that others were in the basketball team, I don't think you're going to have, you haven't hauled in any of the other victims' fathers into court. There is nothing in, and if you read this statement in here, the only thing you have to rely on in this affidavit and in this complaint is the lumping together of Mr. Navely with the other two coaches, and they say together that they failed to report. There is, let me put it to you this way, Judge. Think of a totem pole. If Mr. Navely, if there's any requirement for Mr. Navely as a man who happens to be an athletic director to report these allegations in Hamilton County while he's in a cabin in Sevierville, well then the requirement, you're aware of it, you should issue a summons for the superintendent of the schools, sua sponte, to Rick Smith, because you're aware of the complaint and Rick Smith's the head of the totem pole. You should issue a summons for the assistant superintendent. That was the person who gave, and you're aware of this, who said it was okay to play basketball afterwards. You should issue a summons for the principal of the Ooltewah High School, because you're aware of the complaint, and the principal for Ooltewah High School is the one who Mr. Navely made the call to. So what I'm saying to the court is, of course that's not reasonable, because you're not going to issue summonses to a superintendent, assistant superintendent, and a principal in order to get down to the athletic director, because the action happened in Sevier County. When Mr. Navely, as a father, spoke to people at the hospital, there was a detective present in the room. Again, his son's one of the victims of this case. It is reasonable to believe that when there is law enforcement present who you've talked to, and on a return trip on December 27th, which, by the way, is before you issued this summons, when Mr. Navely, as a father of a victim, is meeting with law enforcement, when his son has met with the Department of Children's Services, it's a reasonable basis to believe that he's up there communicating with the authorities in Sevier County. I would dare say, if Sevier County had any problem with how he was acting either as an athletic director or a father, they have all of the resources available to them. They're the ones who actually issued the, as you know, the rape complaint. So I think that I understand the emotion behind this case, but I think we've got to get back to the basic law, which is before you take a plea, and I understand, as soon as you ask these gentlemen, how do you plead, guilty or not guilty? If Mr. Nadley stands up and says guilty, the jurisdiction is fine only. If he says not guilty, then you immediately lose your jurisdiction and the case goes to the grand jury. I understand how the statute works. What I'm saying is, on this order, that you were presented with information, both the complaint and upon whatever they said at the ex parte hearing, there is nothing reasonable that amounts to probable cause specific to him. Okay? Respectfully, I ask you to dismiss this, Your Honor.
Thank you.
Prosecutions of proceedings under 37-1, 403, etc., 412 gives this court exclusive original jurisdiction to hear those matters. The court has jurisdiction for 37-1, 605 et al. Under the general jurisdiction statute 37-1, 101C. So that's how those give this court exclusive jurisdiction and general jurisdiction. As to venue, the code defines that venue, you proceed under this part in the county in which the child resides. Juvenile Court Rule 3 indicates venues provided under that statute I just provided, as well as Rule 18 of the Tennessee Rules of Criminal Procedure, one that Mr. Houston mentioned a moment ago, but did not point out subsection B of that. If elements occur in one county and elements of the same crime occur in another county, you can venues proper in either of those counties. The failure to report could be pursued there, or it could be pursued here. And so that's why this county has venue and why this court has jurisdiction. As the courts pointed out, the statute, we brought the investigators and the affidavits before the court that sets out failure to report child abuse and sexual abuse. I think Mr. Bowe mentioned it doesn't fall under the definition, but if we read the definitions a little bit more closely, Your Honor, it squarely does. In 37-1, 602, I believe it's subsection C, in this case 1, child sexual abuse means any penetration, however slight, of the vagina or anal opening of one person by the penis. There's several definitions there, Your Honor, that go on to describe that go on to describe sexual abuse, as the court pointed out earlier. And the abuse under 37-1, could be the neglect or inaction of a guardian, caretaker, as the court pointed out. Obviously, Mr. Montgomery and Mr. Williams were the coach and assistant coach, but Mr. Nadley acted more than just as a father, in that he was on the bench as a coach for the final game, and was also involved in the decision-making of the report. He'd been reported these acts and the decision-making process, whether to proceed forward and play the basketball game. And as well, after the third game, through his own words to investigators, the 4 victims admitted to him what had happened. And at that point, he's called the principal and whoever else above that. But it's very clear that no one that cared for these children or had any caretaker for these children during this tournament ever contacted the appropriate authorities after they learned of the abuse and the child sexual abuse. And particularly when they go to the hospital, learn of that, they talk about that, and yet despite all that, they go on, they continue to play another game, and they never bother reporting to anybody. And as contained in the affidavits, the Department of Children's Services becomes aware of this after hearing an initial media report, and then checks, and that none of the three defendants here ever reported any of this to anyone. And so I would respectfully ask that their motions be denied at this time based on those arguments.
All right, let me ask you a few questions.
Sure.
I'd like to know your position on where and if you draw the line of the totem pole that Mr. Davis brings out, and what distinction you make as to his client.
The distinction I make to his client, that he's not just as a father or up the totem pole.
Well, both. The defense position is he was just up there as a father, not as athletic director, not as assistant principal, and if he's to be responsible for reporting, then so is everybody else up the
Okay.
chain.
If he was just there as a father, then he would not have been contacted when the young man had to go, I'll say victim number one, who suffered the most severe injuries. He's contacted by Mr. Montgomery in regard to that throughout the night and the next morning. If he's just there as a father, he doesn't communicate with the principal. He doesn't communicate with people in central office to decide whether or not to play the basketball game, if he's just there as a father. And furthermore, if he's just there as a father, he doesn't assume the roles of assistant coach on the bench for the third and final game. And so I think that's how I would distinguish that, Your Honor.
Now, let me ask you a more complicated question.
Can I respond to that one point? May I ask this on that one point?
You may.
Just on that one point, Judge. He went to the tournament as a father, and when this crisis happened and he was called, he responded. He didn't sit on the bench on any of the games until the final game. When the decision was made by the school to throw this,
I think the question is, did he respond as a father, or did he respond as a school?
he responded as a father.
That's part of the question.
Right, and then when he calls this, if he didn't call the school, right? If he's told about this and he didn't call the school, we tell him, what in the world is he doing? He's at the game. He's there as a father. The decision is made. The three perpetrators are sent home by the coaching staff, not by him. And so then he sits on the bench at the final game to add some continuity, because he is an athletic director who happens to be up there. If he sat on the bench in any of the games before this happened, I'd say, sure, he's part of the coaching staff. But that's not a fact.
Now, that's not the distinction, whether he's coaching staff or not.
Right. I'm just responding to his point.
Under the statute, whether he had an obligation to report.
Right. And your question was, and I'm responding to his response to your question. Your question was, where did on the totem pole? And what I'm saying is, because the court, you and yourself can issue a complaint once you have notice and information about it under 403. So what I'm saying to you, if you've been given information about it in an ex parte hearing, his information, receiving it from the coaching staff and then giving it to the principal, the assistant superintendent, and the superintendent makes him no different. And if he's sitting here, there should be three more benches. And what I'm saying to you is, there's a delineation somewhere between coaching staff and him.
Okay, I understand your
Gotcha.
answer. Okay. Now,
Do you understand this? Okay.
You need to respond.
Do you understand this? Our point is regard to Mr. Davis's argument. I think it's clear. Okay.
The more complicated question, and the big, I'll just say it, the big question in my mind lies in the 600s and the 605, that portion of why we're here. I think they are different than the 400s, than 403, in several ways. Number one, 403 gives me specific guidance on how to handle this matter. 605 does not. And so, an argument can be made, and there's some legitimacy to the argument that 605 is incorporated in 403. There's also an argument that it's not. And so my question really, I'll get to the point, does 605, the violation of 605 of those actually require and give the defendants a right to a preliminary hearing before grand jury, before being bound over? I don't believe 403 does, but that's 605.
403 doesn't, 403 does not, as the court points out. If the court finds that it does, then we can have a preliminary hearing as regard to 605 if the court so chooses. That's fine. We have people in here ready to testify today if the court so chooses. The statute doesn't give us guidance, so it's either we adopt the philosophy of 403 and it's not plead guilty or not guilty and it's bound over, or the court adopts the idea that since the statute's quiet, that we have a preliminary hearing on only as to the 605 part. But unfortunately, it's not clear, and there doesn't seem to be any case law that would interpret that or give anybody guidance in regard to that.
Stay where you are, just a minute.
I'm not moving.
And so your position is that this court retains jurisdiction under the 600 chapter, and if there is a right to a preliminary hearing on the sexual abuse, failure to report sexual abuse, it would be this court's the proper place to hear it.
This court has general jurisdiction according to 605. So if the court adopts a preliminary hearing, after that, I think it goes on to the grand jury like the 400 section.
If the court finds probable cause under that section.
Right.
I mean, 403 seems to be clear that there's no procedure for a preliminary hearing if the court finds there are reasonable grounds. No argument's been made that reasonable grounds to believe is akin to probable cause. But what is the state's position regarding 605? Is it your position that they're entitled to a preliminary hearing or not?
No, I'm not saying that they are entitled to a preliminary hearing. The statute's silent on that, Your Honor. But
it is a Class A misdemeanor.
It is. But if we look at the other 400 section, it sets out to the court a very similar reporting statute of the procedure with which to follow if a violation of that occurs. And so if the statute is silent, I think we have to refer to the 400 reporter for guidance on how to deal with reporting cases, as opposed to infusing other language that doesn't exist in the 400 statute.
All right. We'll probably come back to that.
Okay.
Let me address their their motions to dismiss rely on that under the 605. I'm just generically referred to as 403 and 605. We all know that there are multiple statutes to each. I just don't see how I can deal with the 605 without giving them an opportunity to have a preliminary hearing if they desire.
Okay.
Do you agree? Or you obviously don't agree with
Well, I don't have a problem with them having a preliminary hearing. That's fine, Your Honor. The court found what they found, issued the summons. If the court thinks they're entitled to under the 605, that's fine.
Now,
the state's ready to proceed.
Practically speaking, what's the difference in 405 or 403? Actually, it's 412, I guess.
Correct.
Over to the grand jury, and 412 and 615. Nothing would limit what you were able to present to the grand jury, whether it was this or something else. Is that right?
I think that would be correct, yeah.
And so, practically speaking, we may be talking about a difference in bond. Practically speaking, what are we talking about?
And just so I understand, what difference are you trying to delineate? The difference between the statutes or being bound over the grand jury versus a preliminary hearing, or what difference we?
If I deny the motions to dismiss, and I want to address those in just a moment.
Correct.
I believe the law is clear. I'm to ask them for their plea on the 403 through 412.
Correct.
It's not clear to me as to what I do with the allegation of violation of the 600 statutes.
Correct. Okay. The difference would be, I guess, if matters are bound to the grand jury, the court, a bond would set a reasonable bond in regard to that. And if they don't agree with that, then they can ask that the bond be reduced or remain on their own summons. The law also states, though, that at some point being summoned, you have to report for booking and processing. So the difference would be bond and what amount that would be. The same as if it was bound to the grand jury on an own recognizance and they were indicted, the grand jury and the judge could set a different bond than the own recognizance bond. And nothing precludes that, and I don't know that it does in this situation either.
All right. I think attorneys want to respond to that discussion. Mr. Houston, did you want to say something?
Well, I guess the only thing I wanted to respond to was Mr. Pinkston said something about being ready to have a preliminary hearing now. Frankly, we need to get the officer here who actually investigated the case, and that's the Sevier County officer. The Sevier County officer who has obviously decided that these men did not violate the law and has brought no charges against them. So should the court allow these gentlemen to have a preliminary hearing, we'd like to have a full preliminary hearing and have the investigator who actually investigated the case there. And the court will find out that there was disclosure, that this child was immediately taken to the hospital, and that it was disclosed then. One thing I would like to add again, and I think it's gotten somewhat glossed over, the statute requires immediate reporting. Immediacy, again, could have only taken place in Sevier County, not Hamilton County, Sevier County.
And it did. And
Well,
it did the next day, and it did the next day.
Actually, it did. Actually, it did. And had this, if this court had the benefit of all the investigative reports, this court would know that. All this court has is the affidavits of these two investigators. That's it.
Surely you're not suggesting surely you're not suggesting.
If I may finish, this court does not have the investigative report of the officer who spoke to these gentlemen.
Well, why didn't you bring it today?
Who spoke to these kids. If this court had that, perhaps this never would have been issued.
Mr. Houston, have you looked at the statute as to who the responsible party is to report to?
Yes, I have. Yes, I have. And Judge, if I may address that quickly, sorry to interrupt. It's just like a car accident. When you have, well, if the court will hear me out, the first thing that somebody should do when there's a car accident is get medical attention. You don't leave somebody laying on the street, or in this case, laying in a house, while you go get a police officer. You take them to the hospital. That's what these gentlemen did. Then it was reported to the police judge. Then.
Your Honor, I just have a few things to add. I'll start with Mr. Davis's discussion with General Pinkston, which is Mr. Nadley being on the bench or coaching the game the day after. That's because Coach Montgomery was in the hospital with the child and stayed with the child for about a week. So any allegation that somehow this man said, oh, well, we're just going to leave this child to his own devices and I'm going to hide this or not tell that is absolutely ludicrous. Now I'll turn to the questions that you've been asking, trying to get an answer to as to the 600 series statutory problem. And here's the answer, Judge. 403, that 400 section says anytime you receive a report that you can initiate an investigation by calling DCS and law enforcement and they investigate. Here. Well, General Pinkston can't investigate something that happened in Sevier County without the cooperation of the Sevier County folks who made a decision. Now, I don't know what their relationship is or is not, but I do know that General Pinkston didn't bring the investigative officer here to say these men did something wrong. And in 7 days, we can't get a subpoena issued to that officer to come here. So that discussion shouldn't even take place. But what should take place is that under the 600 series, if there is a competent filing, and we've discussed why it's not competent today, all those reasons, then you can have jurisdiction. And no, the statute doesn't talk about a preliminary hearing. It doesn't even give that option. And that's another constitutional flaw in these series of statutes because, much like public reaction, which caused this filing, we have a knee-jerk reaction to protecting children. And as I stated earlier, this young man who was victimized by these alleged perpetrators was criminally assaulted. And the statutes are clear with their definition, notwithstanding what the general tried to tell you. The statute clearly says what constitutes sexual abuse and sexual assault. He can't blend definitions that he finds in different parts to accomplish his goal of giving you a complaint. So this complaint needs to be dismissed, Your Honor.
Judge, I'll just object to Mr. Bowe somehow suggesting that we don't take our obligation as prosecutors seriously. and we've just filed this out of some knee-jerk reaction, I think, as he called it.
I didn't make that suggestion, Your Honor.
That's exactly the suggestion he made, and I find it very offensive that he would say that, and so I object to that. And as far as the Gatlinburg police detective needing to be here, investigator in my office and Mr. Roundtree of the sheriff's office talked to the same people that the one in Gatlinburg did, so I don't know why, unless they just want to delay matters, why he's needed when they talked and interviewed the same people. And furthermore, the reason is because these children, they're brought back and would have still been under the care of these individuals in this school. And so that's why it's important, and that's why it's more than a car wreck, and it's, I can't even believe that that was entered as a comparable situation, that this should have been reported. And the only individuals that contacted law enforcement were people from the hospital. That was it. None of these individuals contacted law enforcement or the appropriate authorities under the mandatory reporting statute.
Let me just say, before addressing your motions to dismiss, let me say a couple of things, not necessarily specific to these defendants. I'm going to be very cautious in what I say. The only time really I have a media presence in this courtroom is typically in a transfer hearing where some juvenile has been charged with a very serious or serious offenses. And the only reason that I think having media is here, and I've said this many times, is to help get the message out to young people that what some folks tell them is a myth and a lie, and that is that, oh, you're just a juvenile, nothing serious can happen to you, so therefore you carry a gun or you go do this act. And so getting that message out is important. Likewise, what I believe all can agree on are a couple of things. Protecting children is of utmost importance. There are laws requiring reporting of suspected abuse. And, the message to everyone would be, whether you're involved in scouts or a church or a school or anywhere where you have a position of care or trust over children, you better know what your obligations are and don't rely on that organization to tell you. Someone told me, not related to this case at all, but some time ago, that in church training for nursing workers, they instructed the nursery workers that if there's any suspected child abuse, report it to the church. Well, I guess, yes, you should report it to the church, but that certainly doesn't stop the obligation. And all adults, especially adults entrusted in certain positions over children, need to know that and be aware of that. Secondly, I believe we can all agree that this criminal in nature failure to report series of statutes is not perfect. It's really not well written in the big picture. And what most people, the attorneys in the room, know, most people may not know, is we don't have a lot of guidance on how to interpret these statutes. I don't believe there's any case law that's ever dealt with this issue. There's very little legislative history that gives us guidance. And both nationally and in Tennessee, this is an area of the law that is insufficient in that we don't have the proper guidance in the way to apply, in this case, particularly 605 and 403. And that is where the distinction is and where the rub is for me in this particular case. 403, 412, 37-1-412 reads, a juvenile court having reasonable cause to believe that a person is guilty of violating this section may have the person brought before the court by summons or by arrest warrant. Well, that explicitly implies that a finding of reasonable cause is to be made by the judge short or before any preliminary hearing or any other hearing. A juvenile court having reasonable cause to believe that a person is guilty of violating this section may have the person brought before the court either by summons or by warrant. And then the next sentence tells the juvenile court what to do to deal with that. Now, that being said, I believe these defendants are all here properly this morning under that portion, under the 400 statutes. I heard what gave me reasonable grounds, a reasonable cause to believe that there was a failure to report. Now, really all three of you argue venue and jurisdiction. I took an oath, of course, to uphold the law, and that's exactly what I'm trying to do here. The issue of jurisdiction all through the 400 section of those statutes talks about the county where the child resides. Not only that, if not here, where? Well, the argument is obviously that this charge, if at all, should have been brought in Sevier County. The argument for that is that's where the allegations of abuse against 4 victims occurred. And because of the need for immediate reporting, then that's where it should lie. You know, the statute doesn't say telling the doctor is good enough. The statute doesn't say telling a police officer is good enough. There are reporting requirements. You know, at the trial of this matter, it may be a defense, you know, that may play well with a jury if it gets that far. Yeah, I'm saying if it gets that far, it says, I thought the doctor reported it, or I thought the police officer reported it. Well, maybe so, and that may play, okay, I thought the coach reported it. Well, I thought the athletic director reported it. Well, I thought the superintendent reported it. You know, that may be an argument that's made. There's no question that the juvenile court of Sevier County has jurisdiction over children that are to be found within those borders. The same could be said for McMinn County and Bradley County on the way back to Hampton County. There's also no question that I, as children who reside in Hampton County, have jurisdiction over these victims always. And that's in part the jurisdiction that I'm asserting and denying the motions to dismiss on that ground. The charging instrument was not even required. The charging instrument, in this case, I think was done. Well, I don't want to speak for the district attorney, but it's almost in addition to what was revealed to me in the ex parte hearing, for reasonable grounds or not. The complaint wasn't even a requirement under the 400. I think 600 is totally different. 600 is all the statute really tells us for sure. There's some argument that they're intermingled so much that everything that's in 403 applies to 605. But the only thing we know for sure about that 600 series of statutes in 615, the penalty statute, is that it's a Class A misdemeanor. And we all know enough about criminal law to know that criminal defendants in the United States have certain rights. And I think that includes the right to a preliminary hearing on that portion of the charge. And so the argument that the counts or that this whole thing should be dismissed based on the charging instrument is denied. And likewise, the probable cause argument, I understand, believe me, I understand why these lawyers are arguing everything they argue, and they're doing a good job. They're doing a good job representing the clients. But under the 400 series of parts of what we're looking at, probable cause is not even a requirement. And so, again, addressing Mr. Davis's argument specifically, it is reasonable to believe that talking to law enforcement is enough. It may be that that's reasonable. But it doesn't get us beyond 403. So for those parts of the arguments, your motions to dismiss are denied. Now, as to Mr. Davis's argument regarding his client as to the totem pole argument, I agree. There's a question about where do you draw the line and who's responsible and who's not. And I understand the position is that he wasn't there as an official of the school. He was there as a father. However, he was an official of the school, and he is the athletic director. He is the assistant principal, and he was there shortly after the series of events. And so I believe the duty applies to him as well. And so like to hear from defense counsel, because practically speaking, you know, I know there are pros and cons to a lot of different things and strategy and reasons. Your clients have been brought here under 2 separate statutes. Your motions to dismiss are denied under the 400, under 412. We know what to do next. I ask for a plea, guilty or not guilty. Under 600, I believe your clients are entitled to a preliminary hearing. And so, while I'm not asking you what you prefer necessarily, I would like to hear from each of you, including the state, if you would like for me to proceed under the 400 only, or set this matter for a preliminary hearing on the 600. And if you need time to speak to your client, we'll go into recess.
Can you give us a minute?
Absolutely. Court will be in a 5-minute recess.